a guilty plea that I have received from the Commonwealth, I believe. And it is, you may be able, hopefully you can see that. Can you see that?
Yeah.
All right. And that was the first page. This is the second page. Sorry, there's a lot of paper still.
I know, that's fine.
That's got your name on it. It's not your actual signature, but it is an electronic signature. Yeah. There is also a guilty plea for a DUI as well. There's the signature page on, where is it? Oh, there's the signature page on that, right? Okay. Did you read over both of these and discuss them, or have the opportunity at least to discuss them with your attorney?
Yes, I did.
All right. And did you authorize, just because you were unable to physically do it yourself, you know, based upon things being closed and that, did you authorize him to place your electronic signature on there?
Yes, I did.
All right. Before doing that, did you make sure that you understood everything that you were signing?
Yes.
All right. We also have from the Commonwealth a offer, which looks like this.
Okay.
And this is the second page. It's got the same kind of signature on it, right? Did you do the same thing with that document? Did you go over it and discuss it, or at least have the opportunity to discuss it with your attorney?
Yes, I did.
Okay. And did you authorize him to put your electronic signature on it?
Yes, I did.
All right. Now, let's talk about what all this means, okay? Do you understand that you have the right to not to incriminate yourself, which means you don't have to plead guilty or enter a guilty plea at any point in time? You would have the right to a trial where the Commonwealth would have to prove guilt beyond a reasonable doubt. You would have the right to confront and cross-examine the people that gave evidence against you, and the right to put evidence on in your own defense if there is any. You also have the right to appeal. Do you remember discussing those rights?
Yes, I do.
And do you understand that if you plead guilty today, you are waiving those rights?
Yes, I do.
In addition, one of the charges that you would be pleading guilty to is a driving under the influence. Do you understand that driving under the influence is an enhanceable offense, meaning that the penalties for subsequent offenses can be more, can have greater penalties than the penalty for prior offenses?
Yes.
Okay. Now, has anybody threatened you to try to get you to plead guilty?
No.
Are you telling me here today that you are pleading guilty voluntarily and of your own free will?
Yes, I am.
Ms. Holbrook, do you feel like your judgment is impaired for any reason today?
No, I don't.
Have you had any difficulty communicating with your attorney or understanding the documents or the process?
No.
All right. The Commonwealth has made the following offer according to this document that I have. Count one, possession, first degree. Count one, possession of a controlled substance, first degree. That's a Class D felony. The Commonwealth would recommend a 2-year sentence, possible fine, and court costs. Count two, possession of drug paraphernalia. That's a Class A misdemeanor. Commonwealth would recommend a 12-month sentence plus a possible fine. Count three, DUI, first offense. The Commonwealth would recommend a 30-day sentence with 20 days being suspended. DUI, first offender, drug or alcohol counseling, license suspension pursuant to the KRS 189A.070 administered by the Transportation Cabinet, a DUI service fee of $425, and a possible fine and court costs. The total recommendation of the Commonwealth would then be a 2-year sentence, because all of those sentences would run concurrently, right? So a 2-year sentence, the DUI counseling, the service fee, and the license suspension. The Commonwealth would agree to dismiss failure to illuminate headlamps and possession of an open beverage container upon your plea of guilty in this case. Is this what you thought you were agreeing to?
Yes.
All right. Other than the Commonwealth's promise to make these recommendations that they have just made, have you been promised anything to try to get you to plead guilty?
No.
All right. Ms. Holbrook, are you pleading guilty because you acknowledge being guilty?
Yes.
Okay. Specifically, do you acknowledge that on October 20th, 2020 in Barron County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes.
Are you also acknowledging that you operated or were in physical control of a motor vehicle at that time while under the influence of a substance or combination thereof, which impairs your driving ability?
Yes.
All right. Then what I will do, Ms. Holbrook, is accept your plea of guilty to these charges here today. We'll enter a judgment accordingly. We will dismiss those other two charges pursuant to the Commonwealth's recommendation. Let me ask you a few more questions, okay?
Okay.
First question, one of these documents has a Horse Cave address and one of them has a Glasgow address. So can you tell me what your address is?
309 West Dale Heights Drive, Horse Cave.
Okay. All right. The second thing that I need to tell you or talk to you about, we have a probation officer on here. He's going to want to weigh in because you're assuming, and I'll ask you this question in a second, but assuming that you want to go ahead and get your sentence right now, rather than come back in a month or so and get it then we'll need to talk about when you report and how you go about doing it. Okay.
Okay.
All right. So are you asking that I go ahead and do your sentence right now?
Yes.
Yeah. Okay. Well, I mean, that makes sense. All right.
Yeah.
So, yeah. So, I will sentence you in accordance with these recommendations from the Commonwealth. I'm going to waive your fines and your court costs, but you do have a $425 service fee that I will give you 6 months to pay. Okay.
Okay.
And that's payable to the Barron Circuit Clerk's office. You can pay it in increments or all at once. It's up to you. Okay.
Okay. Thank you.
You will also have to do that DUI, DUI counseling or whatever they call it. And since you're living in Horse Cave, you can do it in Hart County. I don't know the places that you can do, but somebody with probation could probably help you out, or the clerk's office in Mumfordville could help you out. Okay.
Okay.
Officer Bennett is here. He's with the Glasgow office. When you start out, you'll have to report to this office for the first time. And then they can go through the process with you of getting your supervision transferred to the office over there that handles Hart County. Okay. So Officer Bennett, what do you need to know?
Ms. Holbrook, if you will just report to the Glasgow office. If you have trouble with transportation, you can call us tomorrow. But you need to report to our office here in Glasgow physically first so we can get you transferred. If you reside in Hart County, then we can get you transferred there.
Okay.
So are you aware of our address here in Glasgow where the probation office is?
I'm not exactly sure.
Okay. It is, do you have something you can write on there?
Yes, I do.
It's 100B Reynolds Road, Glasgow, Kentucky.
Okay.
So you'll just need to report to us in the morning and we'll get you transferred to Hart County and get everything straightened out for you.
Okay.
And Judge, what was the indictment number on this? I don't have it on the docket.
It's a rocket docket, so it doesn't have a number yet.
Okay.
We'll send you, we'll send you one.
Good deal.
When we do the judgment, that's when they'll assign the number. All right. Ms. Holbrook, I hate to see you under these circumstances, but
I know.
But I, hopefully whatever little hiccup we had there, you're on top of it and you're taking care of your business and this will get us, through to the other side. Okay.
Yeah.
Do you have any questions?
No, I don't.
All right. All right. Hang in there. Okay. Take care of yourself.
All right. Thank
All
you.
right.
You too.
Bye-bye.
Bye.
Judge, I also see Cassandra Metz.
All right. Ms. Metz, are you with us? There you are.
Yes, sir.
Okay. It looks like you have what we call a rocket docket plea to do. Is that correct?
Yes, sir.
Let's see. Are you ready to go?
Yes, sir.
Will you raise your right hand, please? Do you swear or affirm that you will tell me the truth, so help you God?
Yes, sir.
All right, thank you. Ms. Metz, we're going to start by my showing you a few different documents here and making sure that you have seen these before, okay?
Okay.
The first one, this one is called a motion to enter a guilty plea. And I'm not expecting you necessarily to read it all right now, but have you seen this before?
I went over it with my lawyer over the phone, and he
Okay.
sent me an email with documentation for me to review.
Gotcha. All right. So after you went over it with him, did you authorize him to electronically sign it for you?
Yes, sir.
Okay. And did you only do that after you were sure that you understood the document and its contents?
Yes, sir.
All right. Thank you. The second document I have is another thing that he's probably emailed to you, but so you can see it. This is the Commonwealth's offer on a plea of guilty, and it's right here, and it's also got an electronic signature on it. So I'll ask you the same thing. Did you review that after he sent it to you?
Yes, sir.
Okay. And did you discuss it with your attorney and again, make sure that you understood everything?
Yes, sir.
And did you authorize him to sign your name to it electronically?
Yes, sir.
Very good. So I need to make sure that you understand a few things. Number one, do you understand that you have the right not to say anything that would prove the case against you or incriminate you, which means that you do not have to plead guilty? Do you understand that?
Yes, sir.
You also have the right to have a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. Do you understand that?
Yes, sir.
You have the right to put evidence on in your own defense and to cross-examine anybody that gives evidence against you. Do you understand that?
Yes, sir.
Last but not least, you have the right to appeal the outcome of your case to a higher court. Do you understand that?
Yes.
All right. And do you realize that if you plead guilty and I accept your plea of guilty, you are waiving the rights that you and I just discussed?
Yes, sir.
Very good. Thank you. Do you understand, or let me back up. Do you feel like your judgment is impaired today for any reason?
No, sir.
Are you satisfied with the amount of time you have had to discuss this case with counsel and to decide how you wish to proceed?
Yes, Your Honor.
Thank you. Ms. Metz, I'm going to look at what the Commonwealth has sent me about the recommendations. Do you understand that the Commonwealth has made the following recommendation? Your single charge here today is possession of synthetic drugs in the second offense. That is a Class D felony. The Commonwealth agrees to recommend a sentence of 1 year and also agrees to put this case on pretrial diversion. So rather than being sentenced to a 1 year sentence, after you enter your plea, your case would be pretrial diverted, meaning that if you follow the rules of your pretrial diversion, at the conclusion of that period, the charge would actually be dismissed. The plea of guilty would be vacated and the case would be dismissed. Do you understand that?
Yes, Your Honor.
All right. And is that what you believed your agreement was when you came in here today?
Yes, sir.
Okay. Your probation or your pretrial diversion would be conditioned on kind of the standard things that you do when you're on probation, which are report to your probation officer when you're supposed to, you stay out of trouble, you don't move without telling them, or getting permission to move, you don't use drugs and alcohol, you don't break the law, and you get any kind of substance abuse treatment that they may recommend after assessing you. Do you understand that?
Yes, sir.
All right. Other than what you and I just discussed, have you been promised anything to try to get you to plead guilty?
No, sir.
Have you been threatened to try to make you plead guilty?
No, sir.
All right. Are you pleading guilty, Ms. Metz, voluntarily today?
Yes, sir.
All right. Do you acknowledge to me that on October the 9th, 2020 in Barron County, Kentucky, you knowingly and unlawfully possessed a synthetic drug, having a previous conviction for possession of a synthetic drug?
Yes, sir.
All right. Thank you, ma'am. I'm going to accept your guilty plea as having been entered freely, knowingly, intelligently, and voluntarily. I'm going to take a look here at your pretrial diversion order because I don't see any reason not to go ahead and sign off on it too, if it's okay. So give me a minute to look at it. While I'm doing that, can you tell me your address to be sure that
Okay.
we've got the right address for you?
Yes, it's 4183 Beechwood Lane, Bowling Green, Kentucky, 42104.
Super, that's what we have. All right, so look, your pretrial diversion will be granted on the condition that you report as directed to probation and parole. You will have court costs of $165, which is payable within 6 months of today, okay? That gets paid to
Okay.
the circuit clerk. You pay that to the circuit clerk in Barron County. You don't have to physically come here. I mean, you can mail it or pay it over the phone or however you want to do that, all right? Now, oh yeah, go ahead. You have a question?
Question, will I be reporting to probation parole in Barron County or in Warren County? Because I reside in Warren County.
That was where I was going next. Your first report will be
Sorry.
to the, no, it's all right. Your first report will be to the office in Barron County because that's where your conviction was. And then when you do that, and we have an officer on here right now who's going to talk you through what you need to do. Once you have done that, they will be able to transfer your supervision to that Warren County office where you can report for future times over there. Okay.
Okay.
All right. So Seth, do your thing. Okay.
All right, thank you, Judge. Ms. Metz, you will need to report to our office here in Glasgow. Do you have a piece of paper and pen on you that you could write our address down?
I'm getting it right now, sir. Hold on. Okay, go ahead.
It is 100B Reynolds Road, Glasgow, Kentucky.
Okay, and who will I be reporting to?
You will be reporting to Investigator Frazier, and she's actually here today. And if you could get here before 4 o'clock today, we'll get you set up and transferred to Bowling Green.
Alrighty.
Okay?
All right, sounds good. Thank you, sir.
All right. So you don't foresee a problem getting over here today to take care of that?
No, sir.
Super. Okay. Yeah, that'll be probably the only time you'll have to be over here if you go ahead and get that knocked out. Okay.
Okay, not a problem. Is there anything that I need to bring, documentation of any sort?
No, ma'am. Just yourself, please.
Alrighty, thank you. I will see you soon.
Okay. Miss Metz, you're free to go. Okay. Take care of yourself.
Thank you, Your Honor.
All right. Very good.
Have a
Guys,
blessed day.
Yeah, you too. We've got Warren County Jail, and I think they're typically on a kind of a short. They usually don't like to have their people out very long. We got Bobby Logan over there, so if you all are able to tell me anything about Mr. Logan, we'll get his taken care of.
Judge, I have given sort of Josh my bottom line in this case. Not sort of, I've given him my bottom line in this case. Josh has indicated that he's spoken with Bobby about it and he needed more time to think about it. So that's where we are.
Yeah, pretty much, Judge. I need more time. I need a little more time to discuss it with him. And he was having something. He was having some papers sent to me that I need to look into that might affect his decision. If we could go out 2 weeks, so I can have enough time to Zoom with him, to schedule the Zoom conference and Zoom with him, I think we might be close to a resolution in this case.
All right, so we're talking the 8th.
The 8th.
Hey, Josh, you should have those papers faxed to you sometime this afternoon.
Okay. I'll check when I go in the office in the morning.
Okay, thank you.
All right, Mr. Logan, we'll see you at, on the 8th, okay, at 1.
Thanks, Judge Alexander. Have a blessed evening.
Same to you.
Judge Michael Jewell is on if we wanted to take care of that one.
Righto. Hello, Mr. Jewell.
Oh, shoot. Is it not working?
His says that he's got mute.
Yes.
All right.
There you
Yeah,
go.
I can hear you now.
I couldn't see you last time. I could hear you, but I couldn't see you last time.
Well, if you had your choice, hearing me rather than seeing me would be the better option, but you're gonna have to do both. All right. Mr. Jewell, let me find your stuff here. I've got a bunch of things.
This corona's
It's
got everything
confusing
messed up.
too, because he has 20F 268 and 20F 286.
Yeah.
So,
Like I need one more thing to confuse me.
yeah.
All right, Mr. Jewell. Okay, so let me ask you, are you able to hear me pretty good?
Yes, sir.
All right, and able to see me pretty good?
Yes, sir.
All right, raise your right hand, please. Swear to tell me the truth, so help you God.
Yes, sir.
All right, thanks. So, Mr. Jewell, let's start with this. This is a motion to enter a guilty plea. It appears that your signature has been put on there electronically. I just want to check with you. Is this something
Yeah.
that you've seen before?
Yes, sir.
All right. And of course, there's your electronic signature right there.
Yes, sir.
Did you look over this or read over it or discuss it with your attorney?
We discussed with my attorney. Yes, I did.
All right. And did you authorize him to put your electronic signature on that? Yes?
Can you hear me?
Yeah, you're kind of cutting in and out.
Yeah, I'm sorry.
It's all right.
Okay, I think is what it was. Can you see me okay?
Yes, sir.
You kind of look like a rock star today.
Do what?
I said, you kind of look like a rock star today on TV.
Oh, yeah.
I'm sorry.
All right. So did you authorize him to put your signature on that document?
Yes, sir.
All right. So you understand what you've signed? Is that fair?
Yes, sir.
Okay. Do you realize that you have the right not to incriminate yourself and you waive that if you plead guilty?
Yes, sir.
You have the right to a trial by jury where the Commonwealth would have to establish guilt beyond a reasonable doubt. You could confront and cross-examine witnesses. You could put evidence on in your own defense, and you could appeal the outcome. Do you understand that you waive each of those rights if you plead guilty?
Yes, sir.
All right. So, Mr. Jewell, do you feel like your judgment is impaired today for any reason?
No, sir.
Under the influence of anything that's making it, difficult for you to understand me or think straight?
No, sir.
All right. This is, and these are in no particular order, but just the order that I picked them up. This is 20F 286. Your charges are possession of a controlled substance, first degree, third or subsequent offense, and tampering with physical evidence. The Commonwealth agrees to recommend 2 years on each count if you plead guilty, to run concurrently for a total recommendation of 2 years. Commonwealth would agree to probate that sentence for a period of 2 years on the condition that you're supervised by probation and parole and that you follow the rules of probation and parole, which would include getting a substance abuse assessment and complying with any treatment recommendations. Is that what you understood in that case?
Yes, sir.
All right. Other than what I just told you, has anybody made any promises to you or any threats to you to try to get you to plead guilty?
No, sir.
All right. Are you pleading guilty today voluntarily?
Yes, sir.
Mr. Jewell, do you acknowledge that on July 26th, 2020, in Berrien County, you knowingly and unlawfully possessed methamphetamine, having at least 2 prior convictions for possession of a controlled substance?
Yes, sir.
Are you also acknowledging at that time that you destroyed, mutilated, concealed, removed, or altered physical evidence that you believe could be used in a proceeding against you with the intent to impair the availability of that evidence?
Yes, sir.
All right. So let's move on to the next case, which is 20F-268. In that case, the Commonwealth, again, here's the offer in that case. There are 3, looks like 3 charges in that one. And here's your electronic signature, right?
Yes, sir.
So in that case, the Commonwealth has agreed to the following recommendations. Count 1, possession, first degree, third or subsequent offense. Commonwealth would recommend a 1-year sentence. Count 2, drug paraphernalia. Commonwealth would recommend a 12-month sentence. Count 3, possession of marijuana. The Commonwealth would recommend a 30-day sentence. All of that would be concurrent, total 1 year. Commonwealth would agree to probate that 1 year on the same conditions as the other case, supervised by probation and parole. Is that what you understood?
Yes, sir.
All right. And the duration would be 2 years of probation, just like in the last case, right?
Yes, sir.
So, Mr. Jewell, other than that, has anybody promised you anything or threatened you with anything to try to get you to plead guilty?
No, sir.
Are you acknowledging that on July 15th, 2020 in Berrien County, you knowingly and unlawfully possessed methamphetamine, having at least 2 prior convictions for possession of a controlled substance?
Yes, sir.
Do you also acknowledge that at that time and place, you possessed drug paraphernalia and marijuana?
Yes, sir.
All right, Mr. Jewell, because of the circumstances, you have 2 options at this point. You could ask me to commission a pre-sentence investigation and put your sentencing off to a later date, or you could ask me to go ahead and sentence you today, and I would do that, okay?
Yes,
That's up to you.
sir. I just go ahead and sentence me today, get it out of the way,
All right.
get it over with.
Okay, well then I'll do that. And in the 20F-286, it's a 2-year sentence and probated for 2 years. In the 20F-268, it'll be a 1-year sentence probated for 2 years. You will report to probation and parole as directed by Officer Bennett, who's on the call right now. And I'm gonna let him tell you what he expects you to do. Okay, you can probably
Okay.
guess because you've heard a couple of these already, but you can probably, he'll tell you. Okay, Mr. Bennett, Officer Bennett?
Sir,
Yes.
so does this take me, since I'm going on probation, does this take me out of U-turn?
Yes.
Okay, thank you.
As soon as we sign off on all this, you'll be reporting to probation and parole, and you won't, unless you have another case that I don't know about. But if
Right.
these are the only 2 cases, yeah.
All right, thank you.
All right, thanks, Judge. Mr. Jewell, if you would report to probation and parole here in Glasgow tomorrow morning at 8 a.m.
8 a.m.
Yes, sir, please. And make sure you wear a mask. And we'll get you taken care of. Do you still reside in Berrien County?
Yes, sir, I do.
Okay. All right. So just be here in the morning and we'll get you taken care of. Okay.
All right, thank you, sir.
Thank you.
You don't need to know where that is. You know where that is, right?
I know where it's at, sir.
All right, fair enough. Do you have any questions of me?
No, sir, thank you.
All right, Mr. Jewell, thanks for your patience. Report tomorrow like directed, and hopefully we'll be in good shape, okay?
Thank you, sir.
All right, take care.
So you don't have to. You're done with her, right?
All right, let's, looks like we might have one more on here, but I don't know who it is.
Judge, while we're in between things, Bruce Brown just sent me a message in the chat feature, and he has James Depp. And Johnny asked me this morning about that case. I don't think that Johnny's had time to get up there and speak to James about the case and about the offers that are out there. And Bruce indicates that he hadn't spoken with Johnny yet either about the global offer that's out. So I told Johnny this morning that I agreed to continue the case. I don't know if he's spoken to you or not, or if he plans on being on this afternoon, but Bruce said he had a mediation he had to get to and wanted to just let you know about that.
That's
All
right,
right.
Judge. Thanks, John.
James Depp. Yeah, John, I hadn't heard anything from Mr. Bell, so I assume he's planning on getting on here. But he probably wasn't going to get on,
Okay.
Till a little later, because I think he's got at least one of these Hart County. I thought he did. Maybe I'm wrong about that. But anyway, do we want to pick another day now, or do we want to wait and pick it after we get Mr. Bell on and then just let Mr. Brown know when it's going to be? I don't care either one. Either way.
Judge, to interrupt, Johnny's been texting me and he can't log on. He needs the link again. I was just going to email it to him. So he'll be on in a second.
It's been the same link for 11 and a half months.
He said that something's happened with his computer logging on to Judge Grice's court. He's not able to.
It's always Bowling Green's fault.
Don't shoot the messenger. I'm just saying.
Yeah, I'm just yelling at you, aren't I? It's not fair. All right. So I think I had a question on the table. I can't remember if anybody answered it.
Yeah, we can just wait till he gets on, if that's okay with you, Bruce.
Yeah, that's fine. And I can't do March 8th just to go. I've got a full day trial that day.
All right. So any day but March 8th will work for you.
Well, and then I don't know that
Within
the
reason.
following Monday, the 15th, I've got a full day trial also.
All right.
But other than those 2 days, yeah.
Okay. Just help me remember that if you don't care. We don't need to hook Mr. Depp up on the 8th or the 15th. All right. We'll get it and just send you notice of it. Okay.
Okay, that's fine.
All right. Thank you.
Thank you, Judge.
All right. Y'all want to, am I the only one that thinks, and I might be, I'm not, but thinks that we need Mr. Bell for one of these Hart County cases? Am I wrong?
We do. He's on Geronald Page.
Yeah. I think we can take up Mr. Bunch or Mr. Ochoa if you want to.
I had
They're
Josh.
both fine,
I
so.
don't know who has Mr. Ochoa. Is that Josh?
It might have been.
Who?
Sanda has Mr. Ochoa.
Oh, okay. I have Josh Bunch in, Judge.
Okay.
Judge,
Yeah, go ahead, Greg. I'm sorry.
we've got this worked out, but I don't have the paperwork signed yet. I had just sent a counter offer to Risa, I believe Friday, and she responded Friday, and sent paperwork on it, but I haven't had time to get up to Hart County since then and now to get him to sign it.
Sure.
I can try to get up there this week and get it signed and have this done Monday.
I'm okay with that. I hate to put you under the gun. I don't know, and I don't really know whether they'll be able to accommodate us in Hart County too. But if there's somebody there that can hear us, I can ask them if they think we could do it on Monday.
Okay.
Judge, I know that in JD Ochoa's case, we'll be asking for a hearing. So if it's easier for them to put Mr. Bunch on the same date, we could do it that day too.
Yeah, that would be 2 weeks if we're doing it, when we're doing
Okay.
hearings.
I mean, 2 weeks is okay with me. I was just thought if it helped everybody, I could get up there quicker, but 2
Yeah.
weeks.
Greg, it would actually be 2 weeks from tomorrow because it'll be on that revocation docket is what Risa's talking about
Okay.
on the 9th on 3/9.
I'm fine with putting it whenever.
Yeah.
You can go ahead and do a electronic sentence and get the trial away, go ahead and get final sentence. You can't do that.
Was that you, Josh? Okay. I couldn't tell who was talking.
Electronic sentence or signature form.
Oh, well, right now I can't, but we could. I don't know if the jail, if they'll take care of that for me or what, but I'll talk with them and see if they'll if I email it to them, if they'll take the paperwork to you for signature.
You could fax it or email it to us.
right now. You can fax it or email it. We can probably do it today. Can we do it today?
I
So,
don't
yeah.
know.
Yeah, I'll fax it here, I'll sign it, and I'll fax it back. Get this out of the way.
Okay, I can email it up there. That's no problem.
Well,
If they give me who to send it to.
You send it to-
So you want to email it?
Yes,
Okay. Hart, COJail@hotmail.com.
I'm sorry, I didn't catch the first step. Could you say that again?
She said hot,
Hart,
heart,
HART, and
Oh,
jail@hotmail.
at Hotmail? Okay. Was there something after Hotmail you broke up and I didn't hear it? .com?
Yep.
Okay. Okay, I'll send it up there.
Also,
right, so I guess Josh, just slip back there into the audience and then hopefully you'll get all that while we're still doing everybody else and we'll come back. Mr. Ochoa is on. The Commonwealth, I think, has filed filed a motion, which was filed on the 17th. Wants a hearing. That'll be doable. It'll be March the 9th.
May I ask a question?
I'm sorry?
May I ask you a question?
Yes, sir.
What I'm not understanding what that would mean with the hearing. What's that? What can you explain it to me just a little bit, please?
Yes, of course, you know you're on probation, right?
Yes, Your Honor.
Yeah. And apparently, according to the record, you were arrested in Hart County on the 11th and charged with DUI, fourth or greater offense, which is a felony.
Yes, Your Honor.
And you're on probation for, it looks like
DUI as well.
DUI third offense. You were also charged, it looks like, with operating on a DUI suspended license. You were only charged with the first offense, but you had pled guilty to that in Barron County. So they're probably going to amend that when they see it, and that'll be another felony. So you got two new felonies. So the Commonwealth filed a motion to revoke your probation, and they want to have a hearing on it. At least now they do. So we'll have to schedule it for a hearing.
Yes, Your Honor. I would just like to make record of this if there's any possible way. My biggest concern is that obviously I have a strong problem with drugs. And so I'm highly interested in doing some type of extenuating long-term treatment program, if that's at all possible. I would like to have a chance to recuperate from this if it's available to me.
Understand.
That's what I'm going to ask for Hart County as well.
Yeah, I understand. And listen, here's what part of the issue is, Mr. Ochoa, and I understand what you're asking and appreciate what your point is. Most of the time, you've got a whole different set of people in Hart County making decisions that we have over here, and they like to talk and see, if everybody can kind of do something that'll dovetail where it works out best, in both cases. And we're not able to do that today. That's why we usually get the motion. We set it for a hearing, a week or two or three, however long it is down the road, and let all the lawyers talk. And they may or may not come up with something, but if they come up with some sort of agreement, I generally go along with it. I reserve the right, obviously, to say I don't want to go along with it, but that happens very rarely, if at all.
I just wanted on the record, Your Honor, if there's any chance at all that I could stay here in Hart County if they agreed to do a long-term treatment, I would be, because they're having an unsecured bond here right now. And I wouldn't be opposed to staying in Hart County until there's a bed available for me to do long-term treatment.
Your Honor,
Okay.
from our perspective, we want a hearing due to the nature of this new offense and what he had just pled to. So
I understand. I mean,
we're not going to be.
yeah, I'm not committing to anything for anybody.
Yeah,
I'm just,
no, I understand that. I just wanted him to
Yeah.
know that we're asking for a hearing.
I wasn't asking for a commitment either, Your Honor. I just wanted it recorded that's my intention here in Hart County.
no, that's fine. I understand. Yeah. Okay.
Thank you, Judge Alexander. I apologize for interrupting you.
No, not a problem. We'll see you in 2 weeks. Okay.
Yes, Your Honor. Will I stay here until I see you again?
You know, I don't really know because I don't know what, if anything, the two jails will work out between them. It's fine with me if you stay there. I'm going to assume that you're going to stay there, but
Yes,
I don't know. Yeah. Okay.
Yes. Thank you so much, Judge Alexander.
Be good.
Okay.
Johnny, are you, ready to talk about Mr. Page's case?
Yes, sir.
Okay. All right. What do you got in mind?
Your Honor, Mr. Page, in Mr. Page's case, what's going on at this time is he's got a pending case over in Hart County. I'm not representing him in that case as of this point, and therefore I'm trying to get a hold of someone to see or waiting to see what's going on over there before we move forward in this. I can't hardly try to resolve this case without some kind of knowledge of what's going on over there. He is able to be released in this court. I think the only thing we're waiting on is his holds in Hart County. So I think we've done about all we can do at this point until I find out how Hart County is going to go, or if he's going to retain me in this case or not. In the other case, I'm sorry, Judge, in Hart County.
Understand. Mr. Page, well, I don't need to know the answer to that. I mean, I guess he's got an attorney or DPA or a private attorney. I don't know which one.
Well, Judge Alexander, I just got indicted on the case over here a couple weeks ago, and then the court, the snow mess caught up. I haven't had the money to retain her. My wife's not working now; she's taking care of her mother, so I've not had the money yet to retain Mr. Bell to take the case over here. I know that y'all was looking forward to let me go to the rehab, which I needed, and I do need to go, but I have not been able to make bond here. I haven't talked to the judge, anything. Judge Sims is the lawyer, is gonna be my lawyer, my judge over here, and I haven't seen him yet.
When do you expect to see him? Do you know?
Well, we supposed to have court last Monday. It snowed it out.
Sure.
And I know the date on that, if you'll give me the second, Judge.
They moved all of those dates to March the 2nd in Hart
March
County.
the 2nd. All right.
There we go.
March the 2nd.
So would you like me to, I mean, obviously we probably ought to put this after that, whether it's a week after that or, because I don't know how much will get done on March the 2nd. I don't know what'll happen, but you want me to put this on the 8th?
That's fine with me, Judge. I didn't know when they put it on back.
Is this, Miss Risa, are you doing this one?
Yes, ma'am.
That's fine with me, Judge.
All right.
Johnny, whenever we get this other money we get from the government, I'm gonna give you that whole check, $1,400 to take the case over here. My girl has not told you that yet. She's been trying to get in touch with Angel to tell her.
She's been talking to her.
Okay, I'm gonna give the whole thing to you though.
Been talking with her.
Here.
All right. So we'll see you on March the 8th unless I hear different.
Yes, sir. Thank you.
All right. Thank you.
Thank you.
Looks like we're still doing the transition of paperwork to Mr. Bunch because he doesn't appear to be reading anything. So
I sent it to him, so.
Yeah.
Or sent it to them.
I understand.
Y'all haven't done Mr. Delp, have you, Judge?
Not yet.
All right.
We'll do them in a minute because the Barron County just jumped on here. Or they're jumping on here. Mr. Gardner, can we talk to Mr. Rice?
Yes, I was going to suggest that, Judge.
What about it?
No way to appear.
We don't have any paperwork either, so. Oh, they're Mr. Rice.
Yep, how you doing?
I'm doing all right, Mr. Rice. How are you doing?
Good night.
Is this Mr. Spears? Is this your case?
Yes, it is, Your Honor.
All right. Mr. Gardner, where are we?
Judge, the court has issued an order finding that Mr. Rice is not competent to stand trial. Based upon that, I think the Commonwealth is obligated to file a motion to dismiss this case because I think that if I remember correctly, it was did not also believe that his it would improve, situation would improve. So I don't see that he'll be competent in the foreseeable future.
Yeah, and let me say for the record that that's correct as far as it goes. And the finding is more that I do not believe that it's something that like with hospitalization and forced application of medication, his circumstances are going to improve to the point of achieving competency. That's not to say that he will not be competent at some point in the future if something happens, because I've known, as you have, Mr. Rice, for some time. And I mean, there are different, sometimes his situation is different than at other times. But for now and for the foreseeable future, I think that the die is cast on that. I'm not ordering him to be hospitalized and have forced administration of medication. I guess that's what I'm trying to say. Okay.
Okay.
All right.
Do I need to tender an order, Judge, or?
Yeah, there isn't any reason to file a motion just because that's an extra step. If you just want to upload an order, I can sign it.
Okay.
All right.
Okay. So Tony, you've got this case will end up getting dismissed. I think you've still got something there in Hart County that you're going to need to deal with, but this case is going to be dismissed. All right.
Okay.
All right. Take care of yourself.
And Judge, his attorney in Hart County is aware of your decision here. So.
All right. All right. Thank you.
Yep.
All right. Can we move on and try to deal with some of these Barron County folks, and then if it's all right, and then come back to Josh?
Yeah, that'd be fine.
That's fine with me, Judge.
All right, good deal. Anybody have a preference for where to start? In Barron? Oh, Johnny, you still on here?
Yes, sir.
Yeah, let's call Mr. Depp up.
Yes, sir.
All right. Where are they? All right. Mr. Gardner, you all were saying, Johnny, before you got on here, where are you? Before you got on here, Mr. Brown was on here and he had another court appearance that he had to slip off to. And I think the issue was that there hadn't really been, you all haven't been able to really get anything coordinated at this point between your case and his case, or your cases and his case. And he asked that we postpone it. I think maybe they'd been in contact. You all have been in contact, but I don't mean to be putting words in anybody's mouth. But
that's correct, Judge. I was supposed to have some motions done today, and due to the inclement weather and other things, obligations, I just wasn't able to get it done. I had contacted the Commonwealth and asked them if they'd be agreeable to allowing me a continuance. I don't think they're objectionable to that, Judge, but as you said, I don't want to put words in anyone's mouth, but I would ask the court for a continuance of a few weeks to try to get my motions and stuff done and get them filed with the court. I've just got a little behind, and I apologize for that.
Yeah, before you were on here, Johnny, I told the judge that I would, agree to continue.
Thank you.
Mr. Brown was not available on the 8th or the 15th because he had prior obligations. So I guess we'd be talking about the 22nd of March.
That's fine, Judge. I think even I can get them done in that amount of time.
You ought to have said that.
I should not have it. All of it.
Johnny, this is streaming live on YouTube. Remember that now.
Yeah.
Oh, yeah. I don't think anybody's watching it.
Oh, man. I'd be surprised.
Yeah.
All right. So we'll go to the 22nd and you do what you're going to do and hopefully we'll have it, know what we need to do at that point. Okay.
Yeah, sure.
All right.
Sounds good.
All right. Is that all you
believe
have?
that's
You have another case,
all I
Jeremy?
have.
All right.
I believe it's it, Judge. Thank you. Y'all have a good day.
Thank you. Let's see. Oh, good Lord. Jeez. Let's see. Michael Carlson. I'm just going to go alphabetical.
Hey, Greg.
Yeah, that's mine, Judge, on Mr. Bunch, I just got to returned the message that when I tried to send that email up there, I must have gotten it wrong. Maybe I didn't get the email address correctly from her.
All right. Greg, try this because I think this is what they said. And I don't think I'll be cutting out like it was.
Oh.
It's HARTCOJAIL at HOTMAIL.com.
Okay. I left the CO out of that address. That's what the problem is.
Okay.
Yeah. Judge, on Mr. Carlson, I'd sent Mike a counter offer. Sometime this weekend. I don't remember exactly when. We've not really talked it over yet as to whether we'll be able to work anything out on it. But if we could have 2 weeks to see if we can get it resolved.
Okay. March 8th.
Okay, Judge.
Hey, Greg.
Yes.
I'll just tell you while Mr. Carlson can hear it. I mean, I'm not going to agree to any type of probation. I mean, we can talk more about it, but that's just not something I'm going to agree to. But I mean, we'll talk more about it.
Okay. Okay.
All right. See you on March 8th. Are we ready for Mr. Kogar?
Judge, we had sent an agreed order that was e-filed, moving it to
Oh, yeah.
April.
Yeah, I think I signed that on Friday and they probably didn't get a chance to get it off the docket. Oh, is it in the file, you think? Yeah, they had run the docket early because of the weather and so they had left this on, but we got an agreed order to pass it. So Josh, we'll be seeing you a little bit later, okay?
Yes, sir. Thank you.
Jackson Dockery.
Judge, on Mr. Dockery, Greg and I have been talking, and he sent me a counter offer, and I sent an email back saying that before I say yes or no, I needed to check with the prosecutor in Mr. Dockery's other felony case that he's got pending out of another county. I think it was Ohio County.
Yeah.
But I need which the charge here stems from his allegedly stealing a car out of that county. So I was going to talk with the prosecutor there and then get back with Greg if we could put this off for 2 weeks.
Mr. Berry, can you do 2 weeks?
That's fine, Judge.
All right, that's March 8th. All right, so we'll go March 8th at 1 o'clock. Caseyon Dugan.
Your Honor, I represent Mr. Dugan.
Okay.
We have received an offer, and I've received some initial discovery from the Commonwealth. Frankly, Your Honor, we're still kind of in the midst of investigating this case. I have not made any counter offers just yet because we are in the process of doing some investigation on the case. I was going to ask for another pretrial conference so that we can have some additional time to complete our investigation. I had also sent Ms. Gardner a request for some information. I think she was actually going to speak to Glasgow PD and see if there was any additional info.
I did. There's not. Any of those things that you requested as far as the photos would be on the body cam, and we don't have any medical records or letters, but I'll respond formally to it so you have it, but I don't have any additional information. But do you have the body cam? Because I know that you requested that.
I have the body cam from Officer Dewberry. I was thinking there were actually 4 officers that responded. If that's the only body cam, then I have it. But
I'll double check in with Amanda and see if she can get those together.
Did you have a day in mind, Ms. Myers, to put that?
Could we set it over till March 22nd, Your Honor?
I can live with that.
Oh. Judge,
Yes.
is there any way I can get a secured bond?
No, I'm not going to do an unsecured bond. No, sir. All right. March 22nd at 1 o'clock.
Thank you, Your
All right,
Honor.
see you then. Mario Frazier.
Mario. Judge, I thought Mr. Frazier was on next week. He wasn't on the docket that we got.
He wasn't on mine either. I think
He's
about-
on the list that they gave me that said these are the people that are in jail and on the docket.
Oh.
All right. Yeah. He's not on the official docket. He's on this impromptu, they write a list docket.
At the super secret docket?
Yeah, this is the superseded docket. Yeah, because it was superseded by the real docket. All right. Paul Harold Gass Jr.
Judge, we have a deal worked out, not e-filed. His guilty pleas.
Okay. Looks like I might have them. Mr. Gass,
Yes, sir.
how are you feeling today?
Fine.
You've gotten quite a substantial haircut since I saw you last.
Yeah, I needed it.
Well, I'm not saying that. Mr. Gass, are you prepared to go forward here with a plea of guilty?
Yes, sir.
Would you raise your right hand, please? Do you swear or affirm that you will tell me the truth? So help you God.
Yes, sir.
All right. Mr. Gass, I the originals too. Oh, I'm not criticizing, I'm just giving her those so that I don't have to leaf through copies. All right, Mr. Gass, you've got two cases, okay? 20 CR 133 and 20 CR 230.
Yes, sir.
Do you have an agreement in both cases?
Yes, sir.
Thank you. And the first thing let's do is let me show you the motion to enter a guilty plea here, okay? That is right here.
Yes, sir.
And on the back, it looks like it's got your signature, and that's a real live signature that Mr. Barry.
Yes, sir.
Not an electronic signature. Did you in fact sign that?
Yes, sir.
Did you discuss it, or at least have the opportunity to discuss it with Mr. Barry before you signed it?
Yes, sir.
Are you comfortable that you understand everything that you signed?
Yes, sir.
And that would include the offer in each case. Commonwealth made a written offer to you in each case. And did you read over and sign those as well?
Yes, sir.
Very good. Mr. Gass, do you understand that you have the following rights which are waived upon a plea of guilty? You have the right not to incriminate yourself. That is sometimes referred to as the right to remain silent. You have the right to a trial by jury where the Commonwealth would have to prove guilt beyond a reasonable doubt. You have the right to confront and cross-examine people that give evidence against you. You have the right to put evidence on in your own defense. You have the right to appeal.
Yes, sir.
All right. Do you feel like your judgment is impaired today for any reason?
No, sir.
Mr. Gass, in 20 CR 133, you have two counts. One is possession of a controlled substance, first degree, second offense. The other one is possession of drug paraphernalia. On a plea of guilty to the controlled substance charge, which is a Class D felony, the Commonwealth agrees to recommend a sentence of 3 years and also agrees to dismiss the drug paraphernalia charge. The 3-year sentence, the Commonwealth agrees, would be probated under supervision of probation and parole. After service of an alternative sentence of 45 days, you would get an assessment from probation, by the social services clinician that works with probation and parole. And if they recommended that you do any sort of treatment or counseling, you would do that. Do you understand?
Yes, sir.
All right. Is that what you believe the agreement to be?
Yes, sir.
Has anybody made any promises to you other than the Commonwealth's promise to make those recommendations?
No, sir.
Mr. Gass, are you acknowledging that on or about November 15th, 2019, in Barron County, you knowingly and unlawfully possessed methamphetamine, having at least one prior conviction for that offense?
Yes, sir.
All right, Mr. Gass, let's turn our attention to your next case. In that case, you're charged with possession of a controlled substance, first degree, third or subsequent offense, possession of a controlled substance, third degree, which is a Class A misdemeanor, and possession of drug paraphernalia, which is a Class A misdemeanor.
Yes, sir.
The Commonwealth agrees to the following recommendations. On count 1, a 3-year sentence. Count 2, a 12-month sentence. Count 3, it says a 3-year sentence, but it means a 12-month sentence. So I'm going to draw a line through that. Can't get 3 years for drug paraphernalia. So
Sorry about that, Judge.
that's all right. I'm only pointing it out because I'm changing something that everybody signed, and I don't want to change it without telling everybody that I'm. So on count 3, possession of drug paraphernalia, the Commonwealth's recommending a 12-month sentence. All of those sentences would run concurrently with one another for a total recommendation of 3 years, probated for a period of 3 years on the same terms and conditions as discussed in the previous case. Is that what you agreed to, Mr. Gass?
Yes, sir.
And other than that, have you been promised anything or threatened to try to get you to plead guilty?
No, sir.
All right. Are you pleading guilty voluntarily and of your own free will?
Yes, sir.
Mr. Gass, are you acknowledging that on January the 19th, 2020 in Berrien County, you knowingly and unlawfully possessed methamphetamine, having at least 2 prior convictions for possession of a controlled substance?
Yes, sir.
Are you also acknowledging that at that same time and place, you knowingly and unlawfully possessed clonazepam, which is a Schedule 4 controlled substance, and that you possessed drug paraphernalia?
Yes, sir.
All right. Mr. Gass, I'm going to accept your plea of guilty in that case and in the previous case, and enter a judgment accordingly. Are you going to be asking for sentencing today or at a future date?
I'd like to go ahead and do it today, Judge. There was one other matter I wanted to add to it. It's not on the agreements, but Mike and I talked about it, is that these sentences would run concurrent with one another.
Okay.
That's correct, Judge.
I'm going to note that as well, okay?
Okay, Judge. I don't think Paul has quite served 45 days yet, so he would have a few more days to before he finishes his split sentence.
Yeah, it looks like to me that he went in on January 28th, and I don't know, there may be some other days, you know, that he would get credit for too, but probably hadn't got up to 45.
Okay.
All right, Mr. Gass, I'm going to sentence you in accordance with these 2 agreements here today. Give you credit for all of your time spent in custody prior to sentencing, and upon your eventual release, which doesn't look like it's going to be too far in the future, you'll report to probation and parole that by 9:00 a.m. on the first business day after, well, no, let's back up. You'll probably get out in the morning, so you need to report to them on the day that you get out, unless it's a weekend, and then you'll report to them on Monday by 8 o'clock or 9:00 a.m. Okay?
All right. Yes, sir.
And I'm not trying to insult you here, but do you know where the probation office is?
Yes, sir.
All right. Then you'll report when you get out and follow your rules. You'll be in good shape. Okay?
Yes, sir.
All right. Good luck, sir.
Thank you.
No. Yeah. He's just, it'll be an order to follow, and we'll calculate it up. Bobby Johnson. Yeah, Bobby Johnson. All right, thank you.
Judge, these are my cases. Mr. Johnson has three cases basically, but one of them is still not up in circuit court yet. But I'd sent another counteroffer or a counteroffer to Mr. Richardson on these cases. And he had sent me back his reply on that, but I haven't gone over and talked with Bobby about it yet to see if he wants to accept that. We're pretty close on these things. If we could reset this to March 8th.
I have, yeah. He has gotten indicted in that other case, but because of the weather challenges and so forth, they're probably getting worked up right now. They hadn't, because I checked at lunch to see if any of them were in there for me to sign off on, and they weren't. But they, we were closed basically 2 whole days last week, and then part of another. So anyway, long story short, that will be ready to go. I can't tell you whether the indictment was exactly the same as what we thought the charges were in district court, because I don't remember that part, but I just can tell you that he did get an indictment in that case.
Okay.
And I don't have it now to arraign him, but I can arraign him either next week, or if you want to pass it 2 weeks and then, you know, maybe do the arraignment and the plea all at the same time. If you all have a plea worked out, then I'll take either option.
We may be able to do a plea next week, you know, sort of a combination of all three of them. I'll just have to see.
Well, why don't I put it on, Monday, which is the 1st, and we'll at least have that indictment worked up. I'll tell them to not do it at 10. We'll do it at 1, and
Okay.
we'll at least arraign him. And then if you all do have something straightened out, we'll get them all done.
Okay, Judge.
All right.
So Judge, I can't get bond or nothing until then?
No, let's get you arraigned at least on that other charge and on that other indictment. And, you know, you may have an agreement. If you do, then we'll get it all behind us. Okay.
All right.
All right.
Thank you.
Thank you, sir. Are y'all ready to talk about Mr. Bunch?
It looked like he was signing something a while ago, Judge, so I'm thinking they must have gotten it to him.
Well, he's ponied up to the chair or to the camera again, so I thought maybe he was ready, but I don't know. Josh, are you ready or no?
I'm ready, but y'all got y'all? I signed a plea deal. Y'all got it where I signed it?
Oh, yeah, I didn't think of that. No, we don't have that back yet. Or do you know where they were sending it?
Send it back to Greg.
Greg Bird.
Email.
All right.
Okay, let me look real quick. I'll send it to Chrissy, Judge.
Do you want me to send you a copy of the offer to get started before you get the signed version of it, or?
I don't mind that. As long as I know he signed it, we can go ahead and start with him. I'm gonna be asking him. He's probably got it there in his pocket.
Yep.
All right. Look here, hang tight. Let me run in here and grab it.
All right. Sir.
Won't be but just a second.
Yep.
Greg, did you have a copy already from the jail?
Yeah, I'm sending the signed copies to Judge.
Okay.
Or to Chrissy.
They can just ignore mine then.
Are you there, Chrissy?
Bird. Hey. You hear me?
Who?
You. Hey, only thing you didn't put on there is where I've been locked up since August 15th. The jail credit. That's the only thing that wasn't on the plea deal.
Well, they won't put that on the plea deal. That'll be on your PSI. Okay.
Okay. We're gonna waive that. All right, thank you.
Well, they'll still do it, but he can
Yeah.
go and do a sentencing today.
Understand.
Okay.
Thank
Judge, did Chrissy get the signed copy? Oh,
Yes, sir.
okay.
I'm ready to go. Josh, raise your hand for me, please. Wait, turn me back on. Will. Okay. Do you swear or affirm that you will tell me the truth, so help you God?
Yes, sir.
All right, thank you. Mr. Bunch, I have here Mr. Berry, just so I know, was there a motion to enter a guilty plea with that?
There's not, Judge. I didn't have one. If Denise could email me one, I'll I'll email that up to him. We can send it on in to you later if you want to.
Yeah, that'd be fine. I mean, Josh and I have done this before, so I'm going to go through it with him, and I think he knows what it takes to enter a guilty plea. But if he has any trepidation about doing it, we won't do it. Okay.
Okay.
Mr. Bunch, that is true, right? I mean, you've seen those motions to enter a guilty plea before, and you've read those and signed those before, correct? Do you have any objection to our proceeding now, and then you sign that motion later when Mr. Berry gets it to you?
I'm good.
All right. The main things I need to make sure that you understand are that you have the right not to plead guilty. We sometimes call that the privilege against self-incrimination or the right to remain silent. If you do plead guilty, you are waiving that right. Do you understand?
Yes, sir.
All right. You have the right to a jury trial where the Commonwealth has the burden of proving guilt beyond a reasonable doubt. You can confront and cross-examine the people that give evidence against you. You can put evidence on in your defense, and you have the right to appeal the outcome. Do you understand that if you plead guilty, you are waiving those rights as well?
Yes, sir.
All right. Mr. Bunch, do you feel like you're under the influence of anything right now?
No, sir.
You feel like your judgment is impaired for any reason right now?
No, sir.
All right. Do you feel like I am rushing you into this process without you having enough time to think about how you want to proceed or to talk to your attorney?
No, sir.
Okay. In fact, we were willing to put this off, weren't we? And you wanted to do it today.
Yeah, I'd rather go ahead and get out of the way.
Yeah. You know that if you wanted to wait until we got that motion to you and you got the chance to look at it and sign it, I would wait. It'd be fine with me to wait. You understand that?
Yes, sir.
All right. Do you feel like anybody is forcing you into this plea today?
No, sir.
All right. Mr. Bunch, the charges that you have on your indictment are as follows. Count 1, fleeing or evading police in the first degree. That is a Class D felony. On a plea of guilty, the Commonwealth would recommend a 4-year sentence. Count 2, driving on a suspended license. That is a Class B misdemeanor. On a plea of guilty, the Commonwealth would recommend 90 days concurrent with count 1. Count 3, speeding 26 over. The Commonwealth would agree to dismiss that on your plea of guilty to counts 1 and 2. Count 4, reckless driving. Commonwealth would agree to dismiss that charge on your plea to count 1 and 2. And count 5, persistent felony offender in the first degree. The Commonwealth would agree to dismiss that charge on your plea of guilty to counts 1 and 2. The total recommended sentence would therefore be a 4-year sentence. The Commonwealth opposes probation. The sentence in this case would be concurrent with your sentence in Hart Circuit Court 20 CR 199, but it would be consecutive with any other previous case that you maybe, the other sentence that you may have. Do you understand that that is what the Commonwealth's offer says?
Yes, sir.
And is that in fact what you expected it to say?
Yes, sir.
All right. Is that what you have agreed to today?
Yes, sir.
Other than what you and I just talked about, do you believe that there was any other promise made to you or any threat made to you or anything else given to you to try to induce a plea of guilty?
No, sir.
All right. Mr. Bunch, are you telling me here today that you are pleading guilty voluntarily and of your own free will?
Yes, sir.
Once again, do you feel like you're being forced into this by me or by anybody else?
No, sir.
Mr. Bunch, are you acknowledging that on August 15th, 2020 in Barron County, you committed the offense of fleeing or evading police in the first degree when you operated a motor vehicle with the intent to elude or flee, and you knowingly or wantonly disobeyed a direction to stop your motor vehicle given by a peace officer, and by so doing, you caused or created a substantial risk of serious physical injury or death to any person or serious damage to property?
Yes, sir.
All right. Are you further acknowledging, Mr. Bunch, that at that same time and place in the operation of a motor vehicle, you were doing so on a public roadway, knowing that your license had been canceled, suspended, or revoked?
Yes, sir.
All right. Mr. Bunch, I'm going to accept your guilty plea today as having been made freely, knowingly, intelligently, and voluntarily. Are you asking for a pre-sentence investigation, or do you want to waive that and be sentenced today?
want to go ahead and waive it and just make sure you got it from when I've been locked up from August the 15th to now, jail credit. But yeah,
All
I'll
right.
wait.
All right. Yeah, I don't know. We have, in this case, you posted a bond on October 21st.
Yeah, I never got out. Hart County, they rejected.
Judge, I can verify. He's been in since August. For sure. I can take a look at his time if I need to do that.
Yeah.
Okay.
Well, I mean, yeah, no, normally what happens, I mean, if there is a controversy about credit, we discuss that in the context of a final sentencing, but that requires a PSI. In this case, all I'm at liberty to say, I guess is the way to put it, is that I would want him to get credit for all of the pre-sentence, custody credit that he's entitled to.
Right. He's still on parole, so I'll have to serve him with some paperwork anyways. So I'll talk to you whenever we get all that taken care of, okay?
Yep.
Yeah, it gets a little complicated once you start doing all that other stuff and factoring in 2 different counties and parole and all that. But I don't want to deprive you of any credit that you're supposed to get. All right, that's the upshot of what I'm trying to tell you. Okay.
Yep.
All right. Do you have any questions, Josh?
Nope. Have a good
Let
day.
me tell you, this is what I want you to do. Mr. Barry is going to be emailing a motion to enter a guilty plea. So can I count on you to sign that when you get it and send it back?
Sure.
Or at least do your part in getting it back. I know you can't send it back, but they'll do it.
I can do it.
Okay. You have any questions?
Nope.
All right. Take care of yourself.
All right.
All right. Thank you all over there in Hart County. Do we got can we do Mr. Justice's case?
Judge, I sent Chrissy paperwork. Did she get that to you?
I believe it's in the file.
Okay.
I did not see it before now, but that is not anybody's fault but mine. All right, let me look. Mr. Justice, I have let's see, 19 CR 378 and 19 CR 264. Plea offer in both cases and a motion to enter a guilty plea. Are you ready to proceed with a guilty plea today?
Yes, sir.
Will you raise your right hand? Do you swear to tell me the truth, so help you God?
Yes, sir.
All right. Mr. Justice, first off, with respect to this motion, which I will show you I'll try to stick it up here where you can see it. All right. Does this look familiar?
Yes.
And this is the signature page?
Yes, sir.
Did you sign that?
Yes, sir.
When did you sign that?
Today?
Today?
Yes, sir.
All right. Bless you. All right. And did you read over it before you signed it?
Yes, sir.
Did you have all the time you needed to discuss it with your attorney if you needed to ask any questions?
Yes, sir.
All right. Mr. Justice, do you feel like you're being forced into signing this agreement by me or by anybody else?
No, sir.
Mr. Justice, do you understand that you have the right not to incriminate yourself? You have the right to have a jury trial where the burden of proof is on the Commonwealth to establish guilt beyond a reasonable doubt. You have the right to confront and cross-examine the people that give evidence against you. You have the right to put evidence on in your own defense, and you have the right to appeal.
Yes, sir.
You understand that if you plead guilty, and I accept your plea of guilty in either one of these cases, then you are waiving those rights that you and I just discussed and you just acknowledged.
Yes, sir.
Do you believe you are under the influence of anything right now?
No, sir.
Do you feel like your judgment is impaired for any reason right now?
No, sir.
Do you feel like you've had sufficient time to discuss these matters with your attorney and to decide how to proceed?
Yes, sir.
Mr. Justice, let us look at these in numerical order. The first case is 19 CR 264, and your charges and the recommendation of the Commonwealth in each case are as follows. Count 1, possession of a controlled substance, first degree, third or subsequent offense. That is a Class D felony. On a plea of guilty, the Commonwealth agrees to recommend a sentence of 2 years. Count 2, drug paraphernalia. That is a Class A misdemeanor. On a plea of guilty, the Commonwealth agrees to recommend a sentence of 12 months concurrent with count 1. Count 3 is possession of marijuana, a Class B misdemeanor. The Commonwealth agrees to recommend a 45-day sentence concurrent with count 1. Count 4 is DUI, first offense. The Commonwealth agrees to recommend a 30-day sentence concurrent with count 1. In addition, there is a service fee, a DUI service fee, a license suspension according to statute, DUI counseling according to statute. Count 5, no insurance, first offense. The Commonwealth recommends, that is a B misdemeanor. The Commonwealth recommends a 90-day sentence concurrent with count 1. Count 6, promoting contraband in the first degree. The Commonwealth recommends a 2-year sentence concurrent with count 1. That's a Class D felony. Count 7, tampering with physical evidence, another Class D felony. Commonwealth recommends a 2-year sentence concurrent with count 1. Count 8, possession of a controlled substance, third degree, Class A misdemeanor. Recommendation is a 12-month sentence concurrent. Count 9, persistent felony offender in the first degree. The Commonwealth agrees on your plea of guilty to these other charges to dismiss that one. Therefore, when the dust settles, the total sentence recommendation is a 2-year sentence plus those DUI penalties that go along with it that we discussed a second ago. The Commonwealth agrees with respect to that 2-year sentence that you would be placed on supervised probation for a period of 3 years after serving a 60-day alternative sentence. You would follow the rules of probation and parole, including but not limited to substance abuse assessment, which they would set up for you, and making any following any recommendations as to that assessment. The alternative sentence in this case will be concurrently served with your alternative sentence in the other case that we're getting ready to talk about. However, the balance of the sentences would be consecutive, so that the sentence in this case would be consecutive to or with the sentence in the next case, as well as any other sentence. Is that, Mr. Justice, what you understood?
Yes, sir. This is my jail time credit.
Say again?
Yes, sir.
All right. Other than what you and I have just talked about, has anybody promised you anything or made any threats or other assurances to you to try to get a plea of guilty out of you?
No, sir.
Are you pleading guilty voluntarily and of your own free will?
Yes, sir.
Mr. Justice, are you acknowledging to me here today that on or about December the 8th, 2018, in Barron County, Kentucky, you knowingly and unlawfully possessed methamphetamine, having at least 2 prior convictions for possession of a controlled substance, constituting count 1, possession of a controlled substance, first degree, third offense?
Yes, sir.
Are you also acknowledging that at that same time and place, you possessed drug paraphernalia, marijuana, and Xanax, constituting possession of drug paraphernalia, possession of marijuana, and possession in the third degree?
Yes, sir.
All right. Mr. Justice, are you also acknowledging that at that same time and place, you operated or were in control of a motor vehicle while under the influence of a substance or combination of substances that impair your ability to drive?
Yes, sir.
All right. At the time that you were operating that motor vehicle, are you acknowledging that you were, that you did not have the insurance required by law on that vehicle?
Yes, sir.
All right. And finally, the last 2 charges, promoting contraband, are you acknowledging that on or about December 8th, 2018, you knowingly introduced dangerous contraband, which was a controlled substance, into the Barron County Jail?
Yes, sir.
Are you finally acknowledging that you committed the offense of tampering with physical evidence when on or about December 8th, 2018, you destroyed, mutilated, concealed, removed, or altered physical evidence that you believe could be used in a proceeding against you with the intent to impair the availability of the evidence in that proceeding?
Yes, sir.
All right. That's got the first case. Your second case is 19 CR 378. Again, the charges and offer are as follows. Count 1, possession, first degree, second offense. On a guilty plea, the Commonwealth recommends a 3-year sentence. That is a D felony. Count 2, fleeing or evading in the second degree. Count 3, wanton endangerment, second degree. Count 4, wanton endangerment, second degree. Count 5, wanton endangerment, second degree. Count 6, leaving the scene of an accident or failure to render aid. Count 7, possession of drug paraphernalia. And count 8, resisting arrest. Those are each Class A misdemeanors. And as to each one, the Commonwealth would recommend a 12-month sentence concurrent with count 1. Count 9, DUI, first offense. The Commonwealth would recommend a 30-day sentence plus the service fee and the other DUI penalties as we just discussed in the prior case. Count 10, failure to produce an insurance card. The Commonwealth would agree to dismiss that charge. The total recommended sentence in this case would be 3 years plus the DUI service fee and the other DUI penalties that we have discussed. The Commonwealth would agree to supervised probation for a period of 3 years after service of a 60-day alternative sentence, which would be served concurrently with the alternative sentence in the other case. However, the balance of the sentence would be applied consecutive with the other case, 19 CR 264, that we just discussed, as well as any other case. Mr. Justice, is this what you believe the agreement to be in this case?
Yes, sir.
All right. And are you entering your plea of guilty today voluntarily and of your own free will?
Yes, sir.
Are you, do you believe that you're being forced by me or anyone else to enter that plea?
No, sir.
All right. Are you acknowledging that on June 2nd, 2019 in Barron County, you knowingly and unlawfully possessed methamphetamine, having at least one prior conviction for that offense?
Yes, sir.
Are you acknowledging that at that same time and place, you, as a pedestrian having the intent to elude or flee, knowingly or wantonly disobeyed a direction to stop given by a peace officer who had a reasonable suspicion that a crime had been committed, and while so doing, you caused or created a substantial risk of physical injury to another person?
Yes, sir.
All right. There are also 3 counts of wanton endangerment with respect to each. Are you acknowledging that you wantonly engaged in conduct creating a substantial danger of physical injury to 3 individuals?
Yes, sir.
All right. Are you acknowledging that at that same time and place, you operated a motor vehicle that was involved in an accident or collision, and that you, which resulted in either injury or property damage, and you failed to immediately stop and ascertain the extent of the injury or damage and provide reasonable assistance?
Yes, sir.
Mr. Justice, are you acknowledging that you, on June 2nd, 2019, possessed drug paraphernalia?
Yes, sir.
Are you acknowledging that you committed the offense of resisting arrest when you prevented or attempted to prevent a peace officer from arresting you by using or threatening to use physical violence against that officer or against another?
Yes, sir.
Are you also finally acknowledging that you operated or were in physical control of a motor vehicle while under the influence of a substance or combination thereof that impairs your ability to drive?
Yes, sir.
All right. Mr. Justice, in 19 CR 264, as well as 378, I'm going to accept your plea of guilty. We will enter a judgment accordingly. Has there been a discussion, Mr. Spears, about whether Mr. Justice would like to have a PSI or would he want to waive that?
Judge, he would like to waive that, and I believe based on what Mr. Justice, I think we figured out that he does have the 60 days already in between his 2 or 3 jail stints he served on this case.
All right. Well, I tell you what I will do, and I don't know that the Commonwealth is in a position to say they agree with that or not. So if they don't, I'll send these files over to Chrissy right now and have her calculate that up. We'll get that all figured up before we even finish here.
Your Honor, I just have not calculated the time in this case, so
Understand.
whatever y'all.
Yeah. Well, and I mean, I wasn't expecting you to have done that. Sometimes you all already have talked about it and you know that that's the case. And sometimes, Mr. Justice, we'll calculate that up, but I'd say Mr. Spears is probably right if he's done that math, but I'll have to look at it and see, or I'll get her to look at it and see.
Yes, sir.
Okay. You're bound to be close if you don't have it all.
Yes, sir.
All right.
Yes, sir.
So we'll let you know before we knock this thing off here. We'll let you know what's going to happen.
Okay, so what am I, sir?
Yeah.
Can I ask one question?
Yeah.
Am I getting supervised probation then?
Yes.
Okay, thank you, sir.
All right. Thank you.
Judge, can we call Cody Rivera?
Hold the phone. Okay. All right. What you got?
Judge, Greg and I have been talking about this case often, but now I've been told that Johnny is representing Mr. Rivera at this point. So I'm not really expecting, I guess we have to pass it off to another date. I don't think there's anything we're going to be able to figure out today.
Is that why you got back on here, Mr. Bell?
Yes, sir.
Okay.
And it'd been my plan to talk to Mr. Riviera. I just got retained on this Friday, Judge.
Okay.
The only thing that I would like to do is maybe address his bond. Is his
well, we had a hearing back about a month ago on the basis of a motion to revoke bond, and the motion was based upon the I believe the charges that ended up turning into this second indictment.
That's true.
And CR 99, Judge,
the 20 CR 99 he was out on bond and got arrested on the charges that ended up turning into 21 CR 028 burglary and T-butt. And we had a hearing on the basis, the Commonwealth filed a motion to revoke bond, and we had a hearing on that. There was also an element of, there was another 4th degree assault arrest that hadn't turned into an indictment that was brought up in the hearing. And if memory serves, there had been a total of like 5 or 6 arrests while he'd been out on bond. So that was basically why I granted the motion.
and that was to hold him without bond, or?
Yes, I granted the motion to revoke bond in 20 CR 99.
Okay.
Which
Well,
is incidentally, that's a Class B felony. So,
And traffic, what's a C felony? It was a traffic and controlled substance 1st degree, second offense, yeah. That'd be a B. Well, is there any way, Judge, we could, at least,
Could I say one thing, please? I hadn't, before this year, I hadn't been in trouble since 2007, 2008. The trafficking marijuana charge, that was in, I think, 2007. I was, I know I really messed up, and if I could get it maybe through U-turn, where I stay clean and
Cody, I think the best thing to do, bud, you do what you want to, but I wouldn't be talking about things like that. You know, all we're addressing is just the charges in front of us. You've done paid your debt on that other stuff, so we'll just face this and move forward and address what's in front of us. If that'd be my advice to you.
I'm sorry.
No, I didn't know.
Well, I mean, yeah, his bond didn't get revoked because he got in trouble 10 years ago. It got revoked because while he was out on bond, he got arrested 6 different times.
Right.
One of which was a felony.
Would the court entertain any kind of ankle monitor, living with his dad, and a consolidated bond on the two together?
I guess I'd probably need to let the Commonwealth weigh in on it.
I'm opposed to it, Judge. I've dealt with Mr. Rivera for the past few years, and he just, I mean, even in the beginning of this case, there was a warrant out for his arrest, and he tried to flee from police in another case when they finally got him served on this. He's had quite a few, he's been in and out of court the last few years, so I don't think an ankle monitor, frankly, is going to keep him from committing any other crime. I mean, he's facing, more than one felony case. I'd like for him to stay where he's at.
I mean, I think he's entitled to some bond, Your Honor.
He had a bond.
I know he had one, but he don't have one now, and I don't think the Constitution says you're entitled to have a bond. I think it says you're entitled to keep a bond of some sort. I mean, I know there's certain, well, I'm not going to argue all that. It doesn't matter. I understand the situation, circumstance, Judge. My position is I would just ask that maybe the court would consider some kind of consolidated bond and some kind of requirements, even at the Commonwealth's suggestion, that they would feel like would make sure that Mr. Riviera was abiding by the court's orders and society's rules.
Well, yeah, I mean, I don't know how far down the rabbit hole we need to go with that. I mean, it certainly defies logic to say that you can have such a thing as bonds and you can have such a thing as revocation of bonds, but then you couldn't revoke a bond. So, I mean, we can have that argument if you want to, but
I don't particularly want to.
It would require a written motion and a hearing if you wanted to do that.
Yes.
Because, again, it doesn't do any good to have a bond and put conditions on it if somebody's going to be able to violate it with impunity. At some point, you have to be called to account on that. And I think getting 6 arrests, I mean, I didn't know about those arrests until the motion got filed because they were all misdemeanors. And then the motion got filed because he picked up a felony arrest. And there we are, but
yes,
it's just got to, it's just got to count for something, or we might as well do away with it. And that's a conversation for another day. But I mean, as long as we've got bonds and we've got rules, I'm obligated to follow them, in my opinion.
Oh, I agree, Judge. Do we know what his assessment is or how long he's been in jail at this point?
I don't. I think we had his hearing about a month ago. It might have been a little longer than a month ago. I think, what did you say? He had a pretrial, and how'd that happen?
He came in, Your Honor, on December the 18th, and he's a high in both categories.
Okay. Which means high risk of reoffending and high risk of failing to appear is what that means.
Yes, Your Honor, that is correct.
All right. Listen, I mean, we've had an evidentiary hearing about the bond. And I mean, at this point, I'm not willing to make any alterations to that. I obviously would listen to any arguments that you wanted to make, Mr. Bell, with a motion and notice to the Commonwealth. I'd be happy to, we do it all the time. So if you all want to do that, I'd be happy to listen. But for now, I'm leaving that order in place. He's already got a pretrial scheduled for April the 12th because they had moved it back when he was out of custody. So that's not ever been taken off. But if you want to do it sooner than that, I'll set one sooner than that.
Yeah, Judge, I'd ask maybe we go to either the 12th or the 18th. I believe we've been set for one of those days, haven't we? I haven't got one.
Well, no, the dates in March would be the 8th or the 15th or the 22nd,
Yeah. If we could put him on for,
or theoretically the 29th. I forgot about the 29th.
if we could put him on for the 8th, Judge,
Yes, I will, if you want me to.
that'd be my motion, Your Honor.
Are you going to have the chance to speak with him before then?
Yes, sir. Well, I'll call and talk to him. If nothing else, if they'll let me.
All right. March the 8th at 1 o'clock. Okay?
Yes, sir.
And the,
Hey, and Cody, if you can, call me collect here at the office, would you?
Okay.
651-7005.
Okay, thank you.
We
All right.
call Colton
Mr.
Keller.
hold on. And Mr. Barry is withdrawn as counsel in that case, for the record.
And Greg, I apologize. I just didn't get the case till Friday, so.
Sorry.
Mr.
I
Keller,
talked to him this morning, he told me.
All right.
so Chrissy. Mr. Keller?
Okay.
Ms. Gardner?
Judge, I think we just need to pass it. I know that Josh and I have been talking. He didn't have discovery in one of the cases. Is that correct, Josh?
I have it. I have it
You have
now.
it now?
I think Darlene must have sent it late Friday because I do have it now,
Okay.
but we do need to pass the week so I can talk, so I can give it to Mr. Keller and talk to him about it now that I have it.
Okay.
When do you want me to put it?
Next week's fine, Your Honor.
Next week? Is
Yeah.
that what you said?
Yeah.
3-1? 3-1? All right. Thank you.
And then I think with Philip Kirby, we might be doing the same thing. I don't know who's representing him.
That's my case. Yes, I've talked with Philip. He has his discovery now. I just gave it to him this morning. But yeah, Mr. Kirby's got a case out of Allen County that he's serving right now. And so if we could put him off for a couple of weeks and I can get back over and talk with him after he's reviewed his discovery and all. Yeah.
Whenever you want it, it's fine.
Who's fine with me?
Your Honor, if I may, I'd like to expedite the process as quickly as possible, kind of get into movement with it and see where we're at and hopefully to move forward at a good clip. If you don't mind to set it, sooner rather than later.
Understand. Mr. Barry, I guess the key would be, what I could do 2 or 3 weeks, just depending on what you thought it would take to get down there.
I think 2 weeks. is fine, Judge.
All right. That's the 8th.
Okay.
All right. Thank you.
Thank you, Your Honor.
And then Jacob Williams is someone that I think we can pass a week. Josh had sent me a counter offer and I sent him a counter offer to his counter this afternoon that he needs to discuss with him.
Correct.
All right, Mr. Spears, what are you thinking?
If we can move this one over to 3-8, I think we can possibly get this taken care of.
All right, we'll do it. March 8th.
The only thing I have left is a rocket docket and it's in 3 cases. So Mike, if you've got something.
There was a couple more I was going to call. Jonathan Kirk, Judge.
Yes, sir. is she on here? The driver's not on here. I didn't think she was on either. How did I get this list with all these people on it? All right. All right. All right, Mike, we got.
Judge, I think we might have a deal in this case. Josh was needing a couple more weeks. If we could do one more pretrial. I told him I needed to check with the victim, and I have, and I've relayed that to Mr. Spears. I think he still needs some time. I don't have the paperwork ready for an agreement because there's 2 other pending F cases that would be a part of it if we resolved all 3. So if we could put it on, is the 8th in 2 weeks?
8th is 2 weeks.
Yeah.
Yeah.
All right, we can do
But
that.
I think we are pretty much have a deal in place. I think it's just a matter of paperwork, but I need to go back over this with Mr. Kirk one more time to make sure we're good on everything.
All right, 3/8 at 1 o'clock.
Is it possible to get out on an ankle monitor or anything until final sentencing, or till we get it all resolved?
Is that a motion to change your bond and give you an ankle monitor?
I mean,
Judge, Josh,
go ahead, Mike.
yeah. Judge, there was discussion they had asked if I would be okay with some type of furlough. And what I told Mr. Spears was, without some type of guilty plea, I'm against any furlough, and I would not take a position. I don't like the idea, especially the offer right now is 8 years to serve on 3 different cases. And here, if he were, let me speak, Mr. Kirk. If there was an agreement in place and everything was signed, I told Mr. Spears I wouldn't take a position. I'd leave it up, Judge. I'd leave it up to you. Ultimately, it's not something I'm not really excited about. But again, if someone's is willing to take responsibility and take an 8-year offer, I wouldn't take a position on whether or not he were to get out prior to final sentencing. But that's all I said, and he needs to talk to Mr. Kirk about that. Without something being signed and anything, I'm completely against any type of ankle monitor, furlough, or anything without an agreement in place.
Yeah, listen, I mean, I don't blame anybody. I mean, if I was in jail, I'd want to get out too, but we talk about this every time. There isn't anything different than there was when we talked about it 2 weeks ago or whenever it was. I mean, I'm not.
Because I told him I'm gonna sign it as soon as, like, it was the part what I was wanting him to see if I could get out on a furlough or ankle monitor to final sentence. And I'm signing it regardless.
Well,
Right,
I know,
which
but I mean, until it gets done, it's not done,
And I need the paperwork.
You know what I mean?
so-
Yeah. So, I mean, I don't get me wrong. I don't think you're standing there lying to me, but I mean, there are all kinds of times that you say you're going to do something and then whatever happens, circumstances change and it doesn't get done. So, I mean, if it gets done, then that's different. But right now, I'm not going to count on it being done. When we go through your plea, if we do, then it'll be done. And then we'll talk. Okay?
Yes, sir.
All right.
Judge also had, sorry.
Go ahead.
Also had Robert Shirley. We have a plea agreement in that.
All right. Do I have it?
I filed it. You should have it.
Got it? Yes, sir. Mr. Shirley?
Sir.
Raise your right hand, please. You swear to tell me the truth, so help you God.
Yes, sir.
All right. Mr. Shirley, looking at a motion here. See that?
Yes, sir.
Okay. What about that?
Yes, sir.
Does that look like your signature?
That's me.
Did you look over this and discuss it with your attorney before signing it?
Yes, sir.
Did you satisfy yourself that you understood it?
Yes, sir.
All right. Are you happy with the amount of time you've had to discuss it with your attorney?
Yes, sir.
Mr. Shirley, do you feel like you're being forced into pleading guilty?
No, sir.
Are you, all right. You understand that you have a right not to incriminate yourself and you waive that if you plead guilty?
Yes, sir.
You have the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You have the right to confront and cross-examine the people that give evidence against you and the right to put evidence on in your own defense. You have the right to appeal. Do you understand that you waive those rights if you plead guilty?
Yes, sir.
You feel like you're under the influence of anything today?
No, sir.
You feel like your judgment is impaired for any other reason today?
No, sir.
All right, sir. Mr. Shirley, the Commonwealth has agreed to recommend the following. On your count of receiving stolen property, $500 or more, that is a D felony. Commonwealth would recommend a 3-year sentence. On your count of persistent felony offender, 2nd degree, the Commonwealth would agree to dismiss. The total sentence there would therefore be 3 years, restitution in the amount of $1,000. The Commonwealth opposes probation, and the sentence would be consecutive to any prior sentence. Is that what you understood your recommendation from the Commonwealth to be?
Yes, sir.
And is that what you have agreed to accept?
Yes, sir.
Mr. Shirley, do you feel like I'm making you do this?
No, sir.
Do you feel like you have been promised anything or threatened with anything other than the promise of the Commonwealth to make these recommendations?
No, sir. Yes. No. Well, there we go.
Do what?
Is it supposed to be a no?
No, yeah.
Yeah. Yeah.
Do you feel like there's part of this offer that I'm not, that we're hiding?
No, sir. No, sir.
This is the whole agreement, right?
Yes, sir. Yes, sir.
And anybody snuck in there and told you anything or tried to threaten you or muscle you around or give you any inducement that I haven't been made aware of, right?
No, sir. No, sir.
All right. All right. Are you acknowledging that on June 29th, 2020 in Barron County, you committed the offense of receiving stolen property when you received, retained, or disposed of movable property belonging to Alliance Corporation valued at $500 or more, but less than $10,000, knowing that property had been stolen or having reason to believe that property had been stolen?
Yes, sir.
All right. Mr. Shirley, I will accept your plea of guilty. Now, are you going to ask for a PSI or do you want to go ahead and get your sentence today?
Final sentence today, please.
All right. Mr. Shirley, based upon the Commonwealth's recommendation, as well as your acceptance of that recommendation and your acknowledgement, I'm going to, like I said, accept your plea of guilty. I'll sentence you to 3 years restitution in the amount of $1,000. That's joint and several with your co-defendant. Has the co-defendant already pled? I don't remember who the co-defendant was.
I'm not sure, Judge. I can check.
Oh, yeah, I don't think so. I don't think there's been a plea in that case. All right. And you'll have to pay that restitution once you get out. You know, we'll start it at $50 a month. I'll give you 90 days from your release date to have to start paying, you know, just so you can try to get your feet under you. Okay.
Yes, sir.
You have any questions?
No, sir.
All right. Your fines and costs will be served out. Okay.
All right. Thanks, sir.
All right. Thank you.
Judge, can we call Stanley Merrill?
Yes, we can.
Josh, is that your case?
Yeah.
Have you talked to him about?
I've talked to him. He's not willing to accept the deal right now. So, I mean, I was going to ask to continue it out towards like March 15th or 22nd and see, and I was going to talk to him some more and go over the discovery a little bit more with him.
I think he's got another indictment.
Another indictment?
That hadn't been done up yet.
Okay.
So, like in that last case, why don't we put it on for Monday and we'll at least get him arraigned and then we'll see where we are.
All right, that'll work.
And if you want me to do it at 1, I will, or we can do it at 10. I don't care, but
let's just,
we might do it at 1 so we can put the pretrial together.
That'll work.
You want us to send you that, Josh, before we do it?
Please.
Can you make a note to have somebody email that? And I guess where we had Bobby Johnson on there earlier, we can email that indictment once it gets worked up to Greg so that they can see them before we do anything. All right, we'll see you on Monday then.
Judge, last one I have is Travis Wilson. And I don't even know if he's on here. Greg, do you know if he's on here?
I thought I saw him.
He's been trying to get in, they said, and he had called and couldn't get it to work. What about, do we still have Timothy Miller in the jail?
He is,
Is that, because that's the only case I've got left in the jail. They probably need to go do something else. Is that another one that's on my list, but he's not on the docket? All right, he isn't on the docket apparently. So, yeah, but he's not in custody. So Bonnie, is that everybody?
That's all I've got, Judge.
Hey, listen, I assume he can hear me. Tell Mr. Justice that he does have his 60 days in, so we'll be sending something down there. You know, he'll just need to report to probation and parole tomorrow by 9 a.m.
Okay, Judge.
Thank you, sir.
You're, you know where the probation office is, right?
Yes, sir.
All right, you got to be there by 9 a.m.
Thank you. You have a good day.
Yep. All right.
Thank you, Judge.
Thank you.
Judge, actually, Wendy Medina is in custody, and she's the rocket docket that has 3 F cases.
Do they not? Bonnie, do you all have Wendy Medina in the room?
Not in the room, but I can go get her.
All right. Well, we'll circle back to you, okay?
Okay.
We have, let's see, I do have Timothy Adams on here.
Can we talk about Travis Wilson real quick?
Yeah, hold on. I've got to find the.
Sure.
Yeah, I've got to find the jail and mute him, but she muted him. All right. Yeah, I don't know what to do with Travis. They said that he called up here because he couldn't get in for whatever reason.
Well, Judge, I was going to say that I meant to send Mr. Berry an offer on Travis this past week, but with the snow and working from home and all that, I haven't gotten around to doing that. I know that he's served out. He has to serve out in his last sentence, and I took that into consideration. So I'm going to send some type of offer for probation to Mr. Berry. I can try to get that out in the next couple of days to him. If we could put it on, I mean, we could put it on next week. Greg, unless you think you need more time for whatever reason.
Go ahead and send it. I'll try to get a hold of him and get it signed and all, but.
Yeah, I was going to see if we could, wait, hold on. Somebody's jumping in here right now.
I think that's him there.
Hello?
Is that you, Travis?
Yes, sir. I was on here just a minute ago and I kept saying hello, so I hung up and recalled back. I've been trying to get on the Zoom, but I don't have internet. I've been on the phone with the clerk this morning.
Yeah, they told me that you were trying to get in.
I waited for over an hour, but I guess it wasn't connected. I don't know.
Yeah, we couldn't hear you. But listen, all we were going to do, Mr. Richardson was going to send an offer to Greg, and he needs to talk to you about it. They didn't get it done last week because of the snow. Everybody was out for 2 or 3 days and all that. Can you get on next Monday?
Yes, sir. What time?
About the same, about 1:30.
Yep. Do I need to call Greg Berry?
Is your number 404-4342?
404-3242.
3242. Okay. Yeah, right there it is in front of him.
I was going to say, I can tell you what it is here in a minute. It's on his.
I was reading it backwards. Okay, that's my dyslexia coming through. Okay, Travis, I'll call you when I get the offer from the Commonwealth. I'll give you a call. Okay.
Yes, sir.
Hey, Travis, we got to be able to see you if we're going to do anything.
Okay, I'll try to connect to Wi-Fi should work, shouldn't it? Through the Zoom
Yes,
app
sir.
on a phone or tablet.
Yes, sir. We have people a lot of times. I mean, are you on like an iPhone?
Right now,
Yeah. What are you on right now?
I'm just on a regular phone. It's not.
Oh, just a
not an
telephone?
iPhone. Yeah, a cell phone.
Okay.
I don't have
Okay.
internet.
I'm with you. So do you have you don't have a smartphone or anything like that?
Well, my mom's got a tablet. That's why I was going to say I could use that to connect like on Wi-Fi and do the video through it. It should.
Yeah, that's what we need to do. Cause if I'm going to take any kind of plea from you, I've got to be able to see you.
Yes, sir.
I mean, I know what you look like, obviously, but
Yeah, I'm trying to get a job and everything. You know what I'm saying? I mean, it's just hard right now with everything that's going on with the COVID and all that.
yeah. Well, Mr. Richardson's making an offer to Mr. Berry and they seem to think that you'll be receptive to it. So let's try to see if we can put you on Monday. That's March 1st and see if we can get it done.
Yes, sir. Will it be probation more than likely, or?
I think all.
Sorry,
Go
Judge.
ahead, Mike.
Yes, it's going to be a probationary offer, but I got to send it to Greg, okay?
Yes, sir.
Yeah, I think hopefully we'll be able to get this wrapped up on Monday, Travis. Okay.
Yes, sir.
All right. See you, man.
I think I'm next.
See you.
Let's get wait, who's down there at the jail? Miss Medina?
Did we want to do TJ Adams first, Judge? I don't
Well,
know that we have.
I think I need to get the jail taken care of.
Oh,
They've
okay.
got to go back to,
I just didn't think we were going to do anything on Adams because I haven't talked to anybody about it.
well,
But that's fine. Whatever.
I'm gonna let, y'all can do some chatting on it if you want to, but I need to get her taken care of so I can let the jail go.
Okay.
Are you Wendy Medina?
I am.
All right. Will you raise your right hand for me? Do you swear to tell me the truth, so help you God?
I do.
All right. Miss Medina, it appears, am I saying your name right?
You are.
All right. It appears that you have got what we refer to as kind of a rocket docket deal. You've got 3 different cases and you've got an agreement in all 3 of them. Is that your understanding?
Yes, Your Honor.
Okay. As you know, because I think you've looked through all this and signed it, there's a lot of papers. So let me
Yes,
work my way through it. Yeah.
a lot of them.
I got to work my way through here and get everything. Okay.
Okay.
But first off, I want to make sure you understand that the only way that we're able to do this is if you agree to do it. You understand that?
Oh, yes, Your Honor, of course.
In other words, I'm not making you do this and nobody else is trying to make you do it. Okay.
Okay.
All right. It looks like all right. There we go.
Still a lot of paperwork.
Yeah. I just got to get through it all. All right. What we've got is a motion in each one of your cases, and we just used the same motion. I mean, it's got 3 different case numbers on it. And this is it right here. Does that look familiar to you?
It does, yes.
All right. And this is the last page or the second page, and that looks like it's got a signature on it. Is that your signature?
It is, yes.
All right. Did you read over this and confirm that you understood it before you signed it?
Yes, the whole entire thing, and made sure it was in order too.
All right. You understand that you have the right not to incriminate yourself. You have the right to a jury trial where the Commonwealth would have to prove guilt beyond a reasonable doubt. You have the right to confront and cross-examine witnesses and the right to put evidence on in your own defense. And finally, you have the right to appeal. Do you understand those rights?
Yes, Your Honor.
And do you understand that you would waive those rights by pleading guilty?
Yes, sir.
Do you feel like I am making you plead guilty?
No, Your Honor.
Do you feel like anyone else is forcing you to plead guilty against your will?
No.
All right. Are you doing this voluntarily?
Yes, I am.
Do you believe that your judgment is impaired by substance or for any other reason?
No, Your Honor.
All right. Have you had adequate time to discuss this matter with your attorney?
Yes, I have.
All right. Very good. All right, so let's look at these. I'm trying to see what, one of these cases is older than the other one, so let's talk about it first. 19F 735. The Commonwealth has agreed to make the following recommendations on your plea of guilty. Count 1, possession of a controlled substance, first degree, first offense. That is a Class D felony. The Commonwealth would recommend a 1-year sentence. Count 2, possession of drug paraphernalia, a Class A misdemeanor. The Commonwealth would recommend a 12-month sentence. Those sentences would run concurrently for a total recommendation of 1 year, possible fines, and court costs. The Commonwealth agrees to probate that 1-year sentence for 2 years on condition that you enter and complete inpatient substance abuse program and aftercare, which is, it looks like is going to be arranged by the U-turn program. I guess you were out on bond and they were supervising you. Is that right?
Yes.
All right.
She's
Have they
got a
already
bed
got that?
date.
Huh?
She has a bed date at Park Place. Isn't that right, Miss Medina?
Yeah, it just said that it was for March 1st. But isn't there because that ride that I had isn't gonna work because he was the one that was in a motorcycle accident, the one that was gonna take me. But isn't there like a way that I would have, you know, the March 1st to be able to get there, but then I can still like be released a couple days or something, you know, because I was told I was going to be released today at first from my attorney, but that way I can be released just to get my stuff in order because he had how he got in his motorcycle accident. He's having his family go stay there, and I just need to get my things and like I just need to get a couple of things in order, but to be there because I know if I understand if I don't show up there, I'm going to be in a lot of trouble. So I'm going to make sure I do go there. I'm going to be there first thing, you know, March 1st at Park Place in Scottsville. When I talked to Julie Atkins, like she was clarifying like exactly where it's at. I know like where it's at and everything.
That was not part of the agreement, Judge, to have her get out beforehand.
Oh yeah, no, it wasn't an agreement. I was saying that my attorney was saying like before that he had said, oh, when you get released, you're probably going to have, you know, the treatment to do. But I was just asking like right now if that would be possible.
Well, what I would probably do, since we already know when your bed date is, would be to let you out, you know, at some point between now and then, not today. And here's why, because first off, if you come in off the street, they're going to make you quarantine before you ever start doing anything, which keeps you from being able to, it either leaves you in there longer or keeps you from being able to complete something within the time frame that you're contemplating. The other thing is if you showed up and you know, heaven forbid, but you tested positive for something, that would throw everything for a loop. I don't have a problem letting you out a few days early, a couple days early, whatever, so that you can have time to make arrangements so that you don't lose everything you got or whatever while you're there, because I don't want you to be worried about that stuff while you're there. I want you to be concentrating on your business at hand and not worrying about, you know, who's stealing your couch or whatever, you know what I mean?
Yeah. Right.
I know how it is. All right.
Okay.
All right. So, but let me back up and ask you. I think we can make this happen. Okay. But but my initial question was just, you already have a bed date and you said yes, and it was March 1st, right?
Yeah. Yes.
All right. All right. Super. So Ms. Medina, in this case, which is the 19F 735, the 1 year recommendation, and that's your understanding, right?
Yeah. Yes.
And inpatient substance abuse treatment and probation supervised by probation and parole, correct?
Yes.
All right. And this case consecutive with your other cases, correct?
Yes.
All right. Are you acknowledging that on December 11th, 2019, in Barron County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes.
All right. Thank you. I'm going to move on to 21F15. Again, possession of a controlled substance, first degree, first offense, Class D felony. The Commonwealth recommends a 1 year sentence. Providing an officer false identifying information, that is a B misdemeanor. The Commonwealth recommends a 90-day sentence. Those will be concurrent with one another. Total of 1 year, 1 year consecutive to your other cases. The Commonwealth agrees to supervise probation on the same terms and conditions as the case that we just talked about. Okay, so is that your understanding in that case?
Yes.
All right. Are you acknowledging to me that on January 9th, 2021, in Berrien County, you knowingly and unlawfully possessed methamphetamine? No.
I did. It was
Hydrocodone or methamphetamine?
oh, it was methamphetamine.
All right.
It is math, and I had sent a corrected version to DPA. I guess Robert didn't have that.
Okay, that's all right. All right, Ms. Medina, are you also acknowledging that at that same time and place, having the intent to mislead a police officer, you gave a false name, address, or date of birth to a peace officer who had asked for that information in the lawful discharge of his or her official duties and who had warned you that giving false information would be an offense?
Yes.
All right. And 21F73, possession of a controlled substance, first degree, first offense. Commonwealth recommends a 1-year sentence. Possession of drug paraphernalia, a 12-month sentence. Probated for 2 years on the same conditions as the other 2 cases. Is that your understanding in that case?
Yes, Your Honor.
All right. And the 1-year sentence would be consecutive as it is in the other 2 cases. Is that your understanding?
Yes.
All right. Are you acknowledging that on or about February 6, 2021 in Berrien County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes, Your Honor.
All right. So here's what we're going to do. I will accept your plea in all 3 of these cases. I would guess that you're gonna want to go ahead and get sentenced today so that we can put this probation in place. You can waive a separate sentencing and we can do it now so we can get because I can't sentence you while you're in rehab. So we want you to get all that done before we go. Okay.
Oh, yeah. Yes.
Seth, are you on here still? Well, he's playing hard to get. You on here?
I am, Judge. My computer just died. I don't know what happened.
All right. There's no need to be coy if you don't want to. All right. So look here. This young lady is going to she has 3 cases. She's getting 1 year plus 1 year plus 1 year for a total of 3 across those 3 cases, 1 year consecutive in each case. We're probating her for 2. She's got a bed date at rehab in Scottsville on March 1st. So my plan is to let her out on Friday so that she can report to you guys and get her probation set up, in the probation office, and then has time to get her personal items and whatever over the weekend and can get to treatment in Scottsville on Monday morning. Okay?
Okay, our office is actually closed on Fridays right now, Judge, but I can arrange something. I can be here. If she can give me a time, I can be here.
I was also thinking, that was the same thing I was thinking, so I can see my kids on Friday. Is there any way I can get out on Thursday? Are you guys open on Thursday?
Well, you're going to get out Friday. We let you out at 6 a.m.
Oh,
so,
okay.
Your kids won't be awake probably.
Yeah, no, probably. Yeah, getting ready for school. Yeah, but I'll be able to see them still. Okay.
But tell Officer Bennett when you can make it, or she can call you. I don't know how you want to do it, Seth, but
no, as soon as I get out of here at 6 in the morning.
You already had this bed date set up, so I'm trying to not make her miss her bed date.
Right.
But I know she can't go straight down there because she needs to meet with you all before she goes. So I'm just trying to make it work.
Yeah, let's just do Friday morning, Judge, at 8 or 9 a.m. whenever she can get here. And I'll take care of it. We can send her on her way.
If I get out at 6, I can be there by 7.
Well, he won't
I'll be here at 8.
Okay, 8, then that'll work.
Yeah, can you be there at 8?
Yeah, I can be there.
You know where the probation office is?
Is it down like Happy Valley area? I'm pretty sure.
Yeah. It's on Reynolds Road, which is, that's right off of Happy Valley or Highway 90, like you're going to Cave City. But it's right there in town, right next to the Don Franklin dealership, the big car dealership there. And
Okay.
I think you'll be able to find it. If we want to give her a phone number, Seth, we can give her a phone number.
Yeah.
Just in case she gets all mixed up.
I'm just not from here, that's all.
Yeah, I saw where your last address was Bowling Green. Is that where you've been
Oh,
living?
yeah, no, that's where I've been living, but no, I'm from California originally. I've been out here getting into trouble the past like 2 years. Like,
Oh, okay. Well, shoot.
but, so I'm kind of glad, like, to get all this done and start over again.
Seth, can you give her a number?
270-791-4940. And you said you were going to do what, Robin?
I will email a packet to the jail for her and she can just bring it with her on Friday.
Okay. Yeah. Robin's going to email a PSI packet to the jail and she can complete it while she's in jail and bring it on Friday morning. That way she won't have to sit here forever and fill that out.
Oh, great. Good deal.
All right.
All right. So Miss Medina, there's been a lot of, moving parts all kind of lined up here. So hold up your end of it. Okay.
Oh, I definitely will.
All right. Do you have any questions?
I don't think so. Well, I don't have to be signed out or anything on Friday, right? I could sign myself out like a big girl and everything, right?
They'll just come get you and take you to the door.
That's awesome. Okay.
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 I mean, I guess that's what they do. I don't know.
Something like that. Yeah.
It's not like a hospital where they roll you out. So, all right. All right. See you. Good luck. Thanks, Bonnie.
Thanks, Judge. Y'all have a good day.
All right, Mr. Adams. Boy, I tell you, I apologize.
It's okay, man. No problem.
These jails, we just can't keep them tied up, and we thought we could.
But I understand it's my own fault for being in the position I'm in.
Well, I thought we could get to you before we started with the Berrien County Jail, but we have to get them done once they get on because they've got another court they got to go to.
Okay.
I've got his file. What's our thought process here, Miss Gardner?
Well, Your Honor, I'm sorry, I didn't mean to jump
Go
in.
ahead.
Originally, this was signed to me, and I think I might have actually done the entry of appearance on it. However, after speaking to Mr. Adams, we've learned that we actually represent one of his co-defendants, so we need to conflict his case out. We've been trying to reach our conflict counsel, but for some reason, we hadn't been able to get a hold of him as of yet. I was going to ask to either pass the case a week or two if the court would be inclined to do that, to allow us to get him separate counsel lined up. I know Mr. Adams is kind of anxious because he's been on an ankle monitor. And obviously I can't continue to represent him, but I know that's one of the things that he was wanting to bring up to the court to see if he could get that condition relieved for him, just because the cost prohibitiveness of it. So in any event, I was going to request that the court either pass the case a week or 2 weeks to allow us to get conflict counsel lined up and to get the discovery and offer over to conflict counsel so they can go over that in detail with Mr. Adams. And then I think Mr. Adams would like to request the court to look at that bond condition requiring the ankle monitor if possible.
All right, let's talk about I can pass it 2 weeks. That'll be fine. I'm afraid 1 week wouldn't be enough time to make anything meaningful happen. And 2 weeks might not be either, but it's going to be more likely than 1. You just listen, I'm not blaming anybody for asking, but you just went on this ankle monitor a month ago, right?
Yeah, I don't know how long it's been, to be honest with you. I don't care to be on the thing. It's costly. And when I thought I had a job when I was in jail, and I got out, and my job let me go because I went to jail, and for the charges that I went to jail for, they let me go from my job. It's just a burden on my parents. They're paying for it. Don't get me wrong, but that's the only reason I asked, man. I'm thankful to be out. I'm thankful. Like I said, it's not the ankle monitor. It's just the money. You know what I mean?
No, I understand, but I'm just going to be honest with you. I put, you got out on the 25th of January, so that was a month ago. And, you know, while I don't expect that I would want you to be on an ankle monitor for, you know, months and months and months, I don't know that I feel real comfortable with 1 month being, you know, getting the job done. I mean, I'd like to have a little bit more of a track record of you not getting in having any issues or anything like that before I consented to that. You understand what I mean?
Yeah, I like I said, it don't bother me to be on the thing. It's just a money thing for my parents. Because like I said, I had a job, and then now I don't. You know what I mean? So
I understand, but listen, we can talk about that the next time I see you, but I'm not going to take you off of the ankle monitor right now just because I don't think it's really been on. What I want is to see, you know, that it's done what it needs to do, which is, you know, get us, you know, not having any problems, doing what you're supposed to do. So far, I have no reason to believe that you have done anything other than what we've asked you to do on bond. So I feel good about it. And I mean, you know, if we got another, you know, little bit of that under our belt, then I'd be pretty receptive to listening to you. Okay.
Okay. Thank you.
All right.
Judge, just for the record, we would oppose it, you know, due to the nature of the charges. I think he needs to keep it on for a pretty long time, actually.
I understand. And again, I don't want him to think I'm promising anything other than I'd be a lot more likely to listen to what you have to say if you're on it a little bit longer.
Okay, thank you.
All right. So that being said, if you want me to go 2 weeks, I know earlier we had a case and Greg was a little worried that he'd be able to get it assigned. I passed it a month and he was a little concerned that might not be enough time. So are you pretty sure that this will be 2 weeks will be enough time?
I've already reached out to the attorney. I'm just waiting for him to confirm that he can take it.
Well,
so that should be.
What was the case that we had him on last week? He was conflict counsel.
It was that Tanisha Shirley?
Yes. So I don't know if we want to maybe put it on that date if it's not too far out.
I don't remember when I think maybe that was March 8th.
No, Judge, it's March 1st because Jason Smith's
March 1st.
Our co-defendant, that was the one we originally set for today, but he couldn't do today, so we had to push it back a week further.
Right. I don't have a problem putting Mr. Adams on for March 1st. I mean, if we think that it's going to be the same attorney, because I already know he's going to be joining us on March 1st.
It shouldn't be an issue. I just have to get the for sure from him.
All right. Well, if we can talk to him on March 1st anyway, because he's going to be joining us for those other, I think he has 2 other cases on that day. Okay. Mr. Adams, can you get back on March 1st?
Yes, that's next Monday, correct?
That's a week from today. Yes, sir.
Okay. Same time?
Yes, sir.
Okay.
Hey, Timothy, do we have your phone number and also we can pass it on to
Yes, as far as I know, Zanda had it. It's my phone number is 270-404-1092.
Okay.
You want my email address as well?
Yeah, that wouldn't hurt at all.
TJ Adams 331@yahoo.com.
Okay. Okay. We'll pass it on to him so he knows how to get in touch with you.
Okay, thank you.
All right, guys. Thank you.
Thank you.
All right. Is there anything else on the docket?
Am I good to go?
Oh, yeah, you're good to go. Thanks.
Thank you.
Yeah. I had a couple of rocket docket cases that didn't get on. Rebecca Brown called and said she had no computer or smartphone or tablet and wondered if she could join with a telephone. And I think they told her no. So,
Yeah. Well, she didn't also, I asked Robert because I hadn't received the signed paperwork back from her.
Yeah.
And I don't think he's had any communication with her to get that done.
Well, we definitely don't have anything signed by her. So
Yeah.
that just goes back in the mix. I
Yeah.
don't have anything signed by this other Eric Conger either.
Judge, that was supposed to be put on for next week. I
Oh,
don't,
okay,
I think that's just a mistake, but he knows to be on next week at 1.
okay. All right. Good deal. All right. Anybody else have something? If not, we'll see everybody bright and early tomorrow.
Judge, you should have that order on Tony Rice. I e-filed that.
Okay, I'll look at it in just a second, okay?
Okay.
All right. And then, Ms. Myers, you stick around if you don't care. Everybody else, we'll let you go.
All right.
And I'm gonna, we gotta stop and she's gotta burn the disc and then I'm gonna put her on this on a separate disc so that it's not part, if anybody came in to look, they wouldn't get it, so.
Okay.
So if you'll bear with me, and I'm gonna run and get your motion because I left it on the desk.
Sure.
What now? Yeah. So when she gets that disc in there, we'll get started. You know, and I know that what you're supposed to do is, I can't remember exactly the wording in the statute, but it strongly implies that you put something on the record every time. Normally, when you're asking for funding, it's like to get Dr. Drogan to come in and everybody knows you're doing it. So I don't ever put anything because there's something stated on the record at a pretrial or whatever. And so I don't ever really have to do this, but I think in a case like this, you know, it's a murder case and we ought to at least make a record of it so that if something happens and there's an appeal there, you know, it shows that we tried to do what we're supposed to do. But she has to burn the disc that we were doing and then stick another one in there. So it'll be a second.
That's fine.